Hello, this is Matt on the Moon Lambeau channel. The SEC is urgently trying to sway the judge to ignore crucial evidence in their case against Ripple. What evidence is it that you're talking about, Moon Lambeau? Yes, well, it's evidence indicating that Bill Hinman, who of course gave his Ethereum free pass speech in June of 2018, the SEC has actually advised to the third party that particular speech, the Hinman speech, be used as market guidance, which is particularly interesting because that's not supposed to happen, because that's not official SEC decree. That's just one man's opinion. That's what they're painting this as, isn't it? Just one man's opinion. But what if it's more than one man's opinion? What if it is official SEC decree, despite the nonsense that they've been saying to the contrary? Well, if that's the case, then if you set XRP to the same standards that are set in the Hinman speech, the fact of the matter is XRP fits the requirements for something to be a non-security better than Ethereum does, and better than both did even back in 2018 when the speech was given. And so this is substantial, and the SEC, understandably, doesn't want this evidence to be considered in the case. It doesn't make them look good. Don't make no damn sense, right? So I've got a legal update on that. And also, I've got a video clip that I transcribed and I want to share with you. And it's something that John Deaton tweeted out, and a couple comments from him on it as well. But before going further, I do want to be clear. I do not have a legal or financial background of any kind. I am not offering legal or financial advice, and you definitely should not buy or sell anything because of anything that I say or write. I'm just an enthusiast who enjoys making YouTube videos all up on the internets about crypto-related topics, but just as a hobby and just for fun. So that's all that's going on here. And so here's the relevant portion. Just to get I want to get the table set here. I'll be as quick as possible in this portion because this is what I covered several days ago when it was the big news of the day. So this document on your screen is from September 24th, 2021. And so there are three documents that Ripple wants the judge to personally review. This is called an in-camera review. So during this video, if I read anything that says in-camera review, it just means in-person review. That's all that means. And so here's what Ripple had to say about these three documents. The descriptions of three of these documents from the belatedly produced privilege log suggest they may be highly relevant to this case. Two relate to meetings the SEC had with law firms to discuss the unprecedented confusion in the market regarding the SEC's view on the status of digital assets under the federal securities laws. The third, and this is the money one here, the bombshell, if you will, the third is an email chain concerning discussions with a third party whom defendants understand received guidance from the SEC to analyze its digital asset under the framework set forth in Director William Hinman's June 14th, 2018 speech. Bam, that is the money shot right there. Yeah, so we don't know who this third party was, but I'm willing to speculate on that. It was probably some, not specific, like I don't know the exact form, I'm not even going to speculate on that, but I'm just saying in terms of speculation, it must have been, don't you think, some firm that launched a coin and wanted to find out what the SEC stance on their coin was, right? And there's been no shortage of ICOs. I mean, currently about, 12,000 cryptocurrencies exist, and I'm not saying that to be flippant. I believe the number is roughly somewhere around there. Yes. And so then they refer whoever this third party is to William Hinman's speech, which is just supposed to be his personal opinion. Yeah, we always knew that it was supposed to be more than that, though. The market perceived it the way that they wanted and expected it to be perceived. That's just the facts of the matter. And so Jeremy Hogan, upon reading this document himself, wrote the following. Just getting back into this case and WTF, legal term. The SEC sent an email to a third party telling them to analyze a digital asset using the factors in the Hinman speech, which speech was just his personal opinion. I understand now. It's the SEC that needs clarity. Yeah, no kidding. And so shout out to James File, an XRP community member who also happens to be an attorney, for sharing that document, as well as this most recent one. And this one's from just yesterday. This is the latest update, September 27th, 2021. The SEC, they don't want these documents to become evidence or be part of the case in any sort of way. And so the relevant portion is just this. Check this out. This is what the SEC wrote to the judge. The 3 additional documents listed on the SEC's September 2 privilege log, for which defendants now seek in-camera review, and again, that means in person, are not responsive to the court's prior orders, reflect deliberations by SEC staff, and have therefore been redacted or withheld pursuant to the deliberative process privilege. The deliberations reflected in these documents are similar to the deliberations reflected in several of the documents already submitted in camera relating to the SEC staff meetings with third parties, including Appendix A, blah, 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 and then they go on to cite that. So if they're so similar, why are you wasting your time writing a letter trying to get the judge not just to throw it out, but to not even look at it? Do you see what's happening here? Because look, the SEC is not just saying, oh, no, this shouldn't be part of the case. The SEC is arguing here that the judge should not personally review the information to find out what's in it. That's what the SEC is arguing right here. What in the ever-loving hell? But are you surprised? Are you surprised? I know the answer. The answer is no, not in the least are you surprised. We've seen how these asshats are managing this case. They don't care about truth or justice or anything of the sort right here. That ethics, what's that? What ethics? I've never heard this word before. No, none of this matters to them. They just want to win at all costs and screw the little guy. The investors out there, the XRP holders, whatever you want to call us, screw us, right? We don't deserve clarity. They say there is clarity. No. There isn't. The SEC has not provided sufficient clarity. There's a lot of things that need to be figured out here. Does this steam your vegetables like it steams mine? My vegetables, they're so steamy. In fact, I'd say they're over steamed. They're soggy and no longer edible. It's not good. They are over steamed vegetables. Well, say it like that. Vegetables. I feel like most people, when they say that word, they take out a syllable. Whatever. I'll make a video on that sometime. But look, I'm just saying here. This is why we can't have nice things, folks. This is why we can't have nice things. And so it's very clear what they're doing here. But don't you think the judge would see this, like see through this? So wait, you're not just saying you don't want this to be in. You're saying I shouldn't look at this, and then why not look at it if what they're saying is true and it's just more of the same? It's going to be in line with what was in other documents that are going to receive an in-camera review. Well, then who cares? If it's the same again, why the hell do you care? Because it's not the same. Because of the reasons that Ripple cited. And the most important one again being that they were advising a third party to utilize William Hinman's speech as guidance, as market guidance, which they're claiming it's not. Today they're claiming it's not. It's just Billy's opinion there. And so what about this? Well, there's an individual named Jeff who shared a video clip of a guy named Lowell Ness who works at Perkins Coie, a very large law firm. You can see counsel to great companies. And so it turns out they were offering counsel specifically to the SEC, more specifically to Bill Hinman. Lowell has. And so Lowell here, he's the guy that's in the center of the screen right there. He said in a different video clip, which is not the one that I'm covering here, but he said it, and I'm sure many of you have heard at this point, but just to make sure, because he said this clip that I'm citing, like it's been widely circulated within the XRP community to this point. But what he said was that Bill Hinman's speech very closely follows a memo that he wrote, Lowell Ness, right there. So go figure. How about that? But it was just Bill's opinion, right? Isn't that supposed to be how this goes? And so there's a clip here, and I'm going to I transcribed this, so I'm going to read this. But first, let me share with you what attorney John Deaton had to say about this. And he said, "This is why the SEC has been fighting over producing the Bitcoin and Ether documents. Listen to what he says. If you get to decentralization equivalent to or more than Bitcoin and ETH, you can't be called a security. The XRP ledger is arguably more decentralized, thus XRP wins. So there you go. Well, that's another reason. Why do you think the SEC doesn't want these documents out? Because it ruins their case, right? It's not doesn't make it look good, at least, right? And so here is what Lowell said in the clip right there. We're going to go eventually with the definition of decentralization as sort of how do we really define who the issuer is for that purpose? And you could make a lot of cases, even with Ethereum. That's a good example where Bill has come out and said Ethereum is not currently. And here's the right way to say it. It's not about the token. The token is never a security. By the way, so let me pause right there. Again, he wrote a memo citing all this stuff. Bill Hinman agreed. The SEC is clearly in lockstep with this. And so if the token's never a security, why couldn't the SEC still choose to sue Ripple if they wanted to, claiming that Ripple sold XRP as an investment contract, certain older transactions, but also acknowledge that the asset itself is not a security so that XRP and holders of XRP would not have taken a severe financial beating? They don't care about that, though. That could not be more. They absolutely could have said that. Hey, just to be clear, because we know no token itself, just by the nature of existing, is a security. It's the way in which it's sold, so on and so forth. I can get behind that, actually. I don't see a reason that would be bad or wrong. But they didn't do that because they don't care about you or me or anybody holding XRP. That's just how it is. So again, the token is never a security. It continues here. None of these tokens are ever securities. But don't think that gets you anywhere because it's really the transaction that matters. And so if you read Bill's speech, it carefully goes through and says the offer and sale of the token, of Bitcoin, of Ether, today does not constitute the offer and sale of a security. In other words, there's no investment contract formed because one person selling Bitcoin to another is not creating an expectation of profit on some issuer's effort. So pause right there. What they're talking about are prongs of the Howey test right there. Expectation of profit. That's one of the prongs of the Howey test. Okay, and then on the efforts of others. That's another prong of the Howey test. It's a 4-prong test. Right? And so that's not happening right there with secondary market transactions. That's very clear. And this is also true of what's happening with XRP, but if you look at the legal language in what in the legal complaint that the SEC has filed against Ripple back in December 22nd of 2020, they're saying that the very nature of XRP existing in the transactions, you've seen me cover this before, right? They're saying that constitutes the investment contract. But that's nonsense. Of course that's nonsense. Anybody with at least half a brain can see that. And so anyway, his comments continue. So the current secondary trading is not a securities violation. That's really what he's saying. But he left open, even in Bitcoin's case, maybe the original primary offering might have been a securities law violation. So in your case, figuring out in your case, where you've got some users using and some buyers reselling, I think as a very practical matter, the 2017 vintage and the 2018 vintage who were out before this no action letter gets published are probably going to have to rely on full decentralization as the tipping point, as the trigger, and you're going to have to get yourself to the same point as Bitcoin and Ether in order to, at that point, no longer be considered a security. And you see, the thing about that is that's actually reasonable, but that's not what's being applied here. That's not what the SEC is doing here. XRP is more decentralized, arguably, than other platforms, other blockchains, including Bitcoin, and was even years ago. And so that's not being recognized, and also the SEC is not clarifying what sufficient decentralization actually is. And that's how you get to the core of this, because one of the prongs is whether or not there's a common enterprise at all of this. And if something's sufficiently decentralized, how the hell is there a common enterprise? Well, then there isn't, which is why they need to flesh that part out. Then we're like 90% of the way there. If you do that in conjunction with Safe Harbor, we're just about good. That would solve so many problems. And I'll go ahead and wrap up there, though. I am not a financial advisor. You should not buy or sell anything because of anything that I say are right. That would be a very, very, very bad idea. Until next time, to the moon, Lambo.